Hello, everybody, and thank you for joining us. I guess we'll begin. Ruth and Cheryl, is that all right? We'll get started.
Yeah, I think that's right, Cheryl. I mean, I guess you'll let us know if there's a problem. Hello, everybody. Welcome to the madness.
Hello, I'm Nick Stephanopoulos. I'm a law professor here at HLS. Ruth, do you want to introduce yourself as well?
Yeah, so my name's Ruth Greenwood. I am a lecturer on law at Harvard. I teach the Voting Rights, Litigation, and Advocacy clinic, and my students all do externships with organizations, so they are in the thick of it. But my regular full-time when I'm not teaching is working at the Campaign Legal Center. I'm the co-director of Voting Rights and Redistricting, and I really focus on redistricting litigation. Although at this time of year, less redistricting, more all elections.
Great, thanks, Ruth. And I should also mention that that I teach and write about election law in addition to other issues, and I've been carefully monitoring some of the exciting and voluminous recent election law developments around the country. So thanks very much to Cheryl for inviting Ruth and me to participate in this event, and also in advance to Cheryl for managing our Q&A session after Ruth and I are done talking. So I'm going to lead off today by discussing the global landscape of pandemic-related election litigation, what's going on across the country in broad strokes, legally speaking. And then Ruth will, I think, although we haven't really discussed this, zoom in on a couple of pandemic-related cases that she's been litigating. And so hopefully this will give you both a sort of general academic perspective on developments across the country and also a more practical perspective from somebody like Ruth, who's active litigating in the trenches on these issues. Let me share my screen with you. Okay, great. So the cases I'll be talking about are very large in number. According to Stanford's COVID-related election litigation tracker, more than 300 election law cases have been filed in more than 40 states over the last 6 or 7 months. There's always litigation in the lead up to an election, but this is by far the most pre-election litigation ever. These cases have addressed all kinds of election regulations. But the most common issues have involved how many polling places there will be, what voting procedures these polling places will follow, what the deadlines will be for requesting absentee ballots and then returning them, whether requirements that absentee ballots be witnessed or notarized are going to be followed or relaxed or even waived, and so on. This map here shows you the litigation activity by just a single set of litigants affiliated with the Democratic Party. You can see that they filed lawsuits in almost every single swing state, and they've achieved at least some success in a substantial number of these claims. So I'm going to talk about 3 categories of litigation that we've seen over the last few months. The first and most common and conventional kind of litigation has been an as-applied challenge to some kind of election regulation, alleging that while this regulation might generally be valid under normal non-pandemic circumstances, it has become unconstitutional under the particular conditions of the pandemic. And so this kind of claim is analyzed under a doctrinal framework that's known as Anderson-Burdick balancing, after the 2 Supreme Court cases where it originated. It's a hybrid doctrine that the Supreme Court has linked to both the First Amendment and the Equal Protection Clause. And it's really the key doctrine protecting the right to vote against burdens that aren't addressed by more specific constitutional amendments like the 15th Amendment or the 19th or 24th. So under Anderson-Burdick, the initial legal question is how severe of a burden does a regulation impose on the right to vote, where to analyze that issue, we take into account the number of people affected by a requirement and the nature of the imposition on voting for these people. Then the doctrine's most unique feature is that the level of judicial scrutiny varies in tandem with the burden. So a light burden on the franchise triggers something like rational basis review, a moderate burden triggers something like intermediate scrutiny, and a severe impediment to voting triggers strict scrutiny. And I'll just note here how unusual all of this is, doctrinally speaking. We have a system of sliding scale scrutiny that we don't see anywhere else in constitutional law. We also have what is nominally an equal protection doctrine that really focuses on the effects of regulations and is not that interested at all in the motivations behind regulations or the classifications that regulations might use. This is all deeply anomalous for an equal protection doctrine. This guy, by the way, is Mark Elias, Democratic super lawyer and the architect of many of the ongoing Anderson-Burdick cases. So what have the main issues been in cases in this category that have been brought during the pandemic? I'll just flag some of them now, and we can discuss further in the Q&A if people are interested. So one issue has been whether an external shock like a pandemic is even relevant to the analysis of the burden that's imposed on the right to vote. Some courts, a minority of courts, have said no. States can't be blamed for forces beyond their control, like a pandemic. So the only relevant burdens are those which are attributable to the four corners of a given election law. Most courts, though, have said that burdens on the franchise arise from the interactions of challenged policies with external factors like people's education, people's mobility, or whether there's an exogenous shock that affects voting, like a pandemic. And so in this view, the coronavirus epidemic obviously is absolutely relevant to the analysis of the burden. A second recurring issue in these cases has been how to think about regulations that most people could comply with if they were sufficiently informed and motivated, but that some non-trivial number of people, in fact, will not comply with. And regulations like deadlines for requesting and returning absentee ballots, and witness and notary requirements for absentee ballots, they all fall into this category. For most people, they're bothersome but not impossible to comply with, but yet some smaller number of people, in fact, won't comply with these requirements. A third issue is what is the strength of the state's anti-fraud interest in this context? That's the usual justification that's asserted by states for election regulations that are being challenged. And so courts have had to think about whether absentee voting is susceptible to fraud and how helpful in preventing fraud are policies like witness and notary requirements for absentee ballots or signature matching for absentee ballots and the like. The last major issue that has come up in these cases is the so-called Purcell principle. This is a doctrine that says that courts should avoid changes to election regulations close to the date of an election because judicial intervention can cause voter confusion. And so courts have had to decide whether the Purcell principle is a rigid ironclad rule that has to be obeyed no matter what, or conversely, whether it's okay for courts to intervene close to an election if they try to minimize the confusion caused by their orders, or if significant disenfranchisement would occur in the absence of a court stepping in. This is an example from Wisconsin of the lines that have prompted some of these Anderson-Burdick cases. Okay, so that's the first category of pandemic-related litigation. The second, less common and less conventional category has involved lawsuits against states that have voluntarily chosen to make it easier to vote during the pandemic. So states like California, New Jersey, Nevada, Pennsylvania have chosen to do things like send mail-in ballots to all registered voters, or extend the deadline for the receipt of mail-in votes, or set up lots of drop-off boxes where people can deposit their ballots. And so lawsuits have been brought against these states, primarily by the Trump campaign and related conservative organizations. One claim against these laws is that they make it easier for election fraud to be committed because they supposedly include fewer safeguards against fraud. And the fraudulent votes that then result supposedly dilute the valid votes that are cast by honest, law-abiding citizens. And allegedly, this violates the 14th Amendment. Another claim against these policies is that they cause too much geographic variation in election administration, and therefore that they violate the principle established in Bush v. Gore, which says that such large degrees of variation are impermissible. The logic here is that states like Nevada and Pennsylvania have required counties to have at least a certain number of drop boxes, but they haven't barred counties from setting up more than this minimum number. And so there's variation from one place to another within a given state in terms of the volume of drop boxes. This guy is one of the main conservative lawyers who has been bringing these cases on behalf of the Trump campaign. Okay, so one concern about these Category 2 claims is whether vote dilution via fraud is even a cognizable constitutional claim. There are several species of vote dilution that the courts do recognize: malapportionment, racial vote dilution, partisan gerrymandering, which is basically partisan vote dilution, used to be recognized as a distinct theory until last year. But the courts have never recognized claims of vote dilution via fraud. The courts have often recognized that certain federal statutes prohibit election fraud, but that's not at all the same thing as saying that the Constitution itself prohibits election regulations that are overly vulnerable to fraud. Another issue in these cases is how to think about fraud prevention when it's deployed as a sword by plaintiffs rather than as a shield by defendants. So in the Category 1 cases, fraud prevention comes up all the time, but it comes up when states assert it as a justification for challenged policies. And so in that context, courts usually don't require a lot of proof that fraud is ongoing or that a given regulation would prevent fraud. But in these Category 2 cases, the state is not asserting fraud prevention as an interest. The plaintiffs are. The state doesn't think that its policy will contribute to fraud. The plaintiffs do. And if the anti-fraud argument succeeds, the policy gets struck down. It doesn't get upheld. So for these reasons, maybe it makes sense to impose a heavier evidentiary burden on plaintiffs in these Category 2 cases than is levied on defendants in the Category 1 cases. And then the final issue here is whether Bush v. Gore claims can ever succeed when, yes, there is geographic variation in how elections are administered, but it's all above a reasonable threshold. So for example, when states require that localities provide at least X number of voting opportunities, but they allow localities to offer more than X voting opportunities if they want, could there possibly be a Bush v. Gore claim? If there could be, then that would strongly push election systems toward central control and statewide uniformity, which might be a good thing, but it would be quite a different model from the one that we've generally followed with our decentralized election systems. Okay, then the final litigation category, which is really emerging as we speak, involves claims that certain non-legislative actors have usurped or violated state legislatures' authority over presidential elections. So Article 2, Section 1 of the Constitution says that the legislature thereof in each state gets to direct how presidential electors are going to be appointed. It gets to pick the mode of appointment for the electors. And so the claim here is that whenever other actors get too involved in regulating presidential elections, be they state courts, state executive agencies, maybe state governors, they violate this exclusive power of state legislatures over running presidential elections. This claim has its roots not in the Bush v. Gore majority opinion or the per curiam opinion, but rather in Chief Justice Rehnquist's three-justice concurrence in Bush v. Gore. In that concurrence, Chief Justice Rehnquist suggested that there was a constitutional problem back in 2000 when Florida state courts got too involved in interpreting and arguably misinterpreting statutes passed by the Florida legislature about regulating presidential elections. So that's sort of the ground zero of this particular claim. And so far, this claim has arisen exclusively in states that have Republican legislatures, but then other Democratic-leaning state actors who in various ways have done things pertaining to the presidential election that the legislatures didn't want. These actors have primarily been state courts dominated by Democrats, but they've also included things like state election boards, which again are distinct from the state legislature itself. And I just want to flag here, the Supreme Court has not yet ruled in favor of any of these legislature thereof arguments, but the court, several justices on the court have expressed considerable sympathy for these claims. And depending on what happens next week, we may see this issue returning to the Supreme Court. So I wanted to flag in closing what some of the radical implications are of this legislature thereof argument. If it really is the case that the state legislature and only the state legislature gets to regulate presidential elections, then it's not clear that gubernatorial vetoes have any power in this context, because obviously the governor of a state is not the state legislature. It's also not clear that state courts have any role to play, even if they're enforcing their own state constitution. Similarly, state constitutional provisions that purport to regulate presidential elections, and these are ubiquitous, might also be invalid because, again, state constitutions are distinct from state legislatures themselves. And any deviation from state law by state executive officials, the Secretary of State, state election boards, state canvassing boards, those might also be unconstitutional because once again, somebody else has interfered with the will of the state legislature as it pertains to presidential elections. So if this is the road we're on, it's a road with really dramatic consequences for state regulation of presidential elections. It might make this old case, Bush v. Gore, look like a minor dispute compared to what's coming now. And so I'll stop with that and turn the floor over to Ruth.
Well, thank you for that bright and optimistic outlook on election day, Nick. That's great. So hello to everyone. I was going to talk to you about what I did with litigating a preliminary injunction this year. Actually, I litigated it in Arkansas, which is in the 8th Circuit. We ended up before Judge Gratz, who did not rule with me. And I see in the Minnesota decision, he did not rule with the good guys either. So I guess I'm not totally shocked. In terms of the application of this in terms of election day, once you get to election day, you have to do preliminary injunctions or temporary restraining orders. That's kind of all you've got. I mean, I guess in some cases you could have cases that are open and you could file a PI in an existing case. But courts generally have some judge ready, so you can very quickly file a complaint and a PI and then get in and get a hearing. So I'm going to go over how we did this with respect to actually a ballot initiative in Arkansas and the worry that we had about gathering signatures during COVID. So this came out, we were working for the League of Women Voters. They were trying to get an initiative to develop an independent redistricting commission in Arkansas on the ballot. And in March, when they were about to start gathering signatures, they were like, maybe we should stay home for 2 weeks. And then after they'd been home for 2 weeks, it was April. And they called us up and said, I don't know if we're going to be able to gather any signatures, COVID's causing this problem. And so we said, well, the Anderson-Burdick test that Nick talked about is designed to look at burdens on the fundamental right to vote, but actually the Anderson case was originally about gathering signatures for a candidate. And so it can also look at burdens on other voting associated rights. And so I don't think I need to go into that aspect of the case, because at the moment when cases come up, they're probably going to be about the right to vote, because that's what's happening in the next week. In that case, though, we had the right to associate, freedom of speech and so on. But in that case, we really had a hard time defining the burden because we had to say, okay, well, because of COVID, people are being careful and staying home. And so it's going to be hard for us to interact with people and get them to sign a petition. And in the Arkansas law, you need a witness, and then the person who witnesses that has to get the fact that they witnessed it notarized. And so that's a series of in-person interactions. And this is still at the point where we were like sanitizing every package that came into the house, and you couldn't even buy hand sanitizer because it was out of the shelves. So when we filed this in April, we couldn't work out, or the campaign couldn't work out, how they were going to safely gather signatures. And so that became the burden that we discussed. And the remedy that we proposed was one of them was to gather signatures online. That actually, as part of my clinic, one of my students was still a student of mine in April, and in Massachusetts, you may see the Yes on 2 signs around. They are there because Mo Light wrote a complaint to say that given the burden of COVID, the Yes on 2 campaign should be allowed to gather signatures online. And here in Massachusetts, the Supreme Judicial Court said yes, and allowed that to happen. And so maybe some of you signed online and were able to support the campaign without endangering your health or your family's health. So we thought, great, let's try to do this in Arkansas as well. And my student is more successful than I am already. And he managed to make it work in Massachusetts. We actually won initially in Arkansas with our district court. The judge was very careful not to give too broad a remedy. Nick touched on it a little bit, that this issue has been coming up with, can the judges be creative with the remedies that they formulate, because historically judges, have been, but these days there's a lot of deference to the legislature to get to choose what the remedy is. And now it's weird to give deference if you are trying to do a action and then wait for the legislature to do something and then come back and decide if that's okay, if you are doing this in a matter of hours on election day. Honestly, even trying to do it within a matter of days in April was hard enough. Anyway, so in our case, we had to file a complaint, file the preliminary injunction motion, and then get together a bunch of evidence, a series of declarations. So we spoke to people across the state, we spoke to vendors and people who were involved, we got declarations and filed all of them. Then the court asked if the other side wanted to do any sort of limited discovery. I know that you can actually, in fact, another PI that my organization CLC worked on in Arizona, it wasn't just an oral argument on the preliminary injunction motion that they just did. They actually put on evidence. So the person that had signed a declaration, they did direct and cross and so on. And so it is possible to do those things on election day in court. And that's why there's this army of election protection lawyers that are nonpartisan, and there are also armies that are partisan for the various parties. Anyway, so you try to outline the burden, and this gets a little bit at one of the questions that got asked. Why do the courts consider fraud prevention to be such a significant state value? Part of it, from my perspective, is it's what the court said in Crawford, and every sort of brief since then cites that and says, oh, well, the court says that fraud prevention is a substantial state interest, and so you need to show a very heavy burden if you are trying to say that that despite that interest in fraud prevention, we should do something different. So anyway, so in our Arkansas case, we managed to explain the burdens, and essentially the judge was like, look, the burden of maybe, meeting with someone in person, maybe there's a way that you can do it, but then also getting that notarized. We, for example, had a man who has terminal cancer, and he said, look, his wife could witness his signature, but she couldn't then go and meet with a notary because the whole point was neither of them were meeting with anybody except his doctors. And so they said, well, we could have people essentially sign forms and witness themselves and declare under penalty of perjury that they were who they say they were and send in those forms. That was the judge's way of getting around that particular burden. When we went up to the Eighth Circuit, eventually, in a decision authored by Gratz, Judge Gratz said, look, we just don't think that that's such a big burden. I think he said something like, you could gather these signatures through a window from a distance, which is kind of insane. What are you going to do, like throw the piece of paper around the window? I don't know. At some point, you have to have this interaction, and that's what people who are immunocompromised are really worried about. So anyway, I mean, in the end, the other place where I did this case was in North Dakota, and in both Arkansas and North Dakota, they managed to get a decent amount of signatures. And then we saw a huge increase, not only because of that, but a huge increase in the amount of people with COVID. And I mean, I'm guessing that many of them interacted in gathering these signatures. But anyway, that's where those cases ended up in terms of the burden versus the sort of state's interest in protecting its procedures and making sure that it has the right number of witnesses and so on. If we look at the, so before I talk about the Minnesota decision, in terms of election day, there are a series of actions that might be taken. So Anderson-Burdick is one, right? Something is happening and it is causing a burden on the fundamental right to vote. That thing might be long lines. It might be broken machines. Depending on how it happens, it could be intimidation or problems, of police turning up at the polls or something like that. So you could be bringing an Anderson-Burdick claim. Nick mentioned Bush v. Gore. So in that case, you would want to be presenting evidence of regional variation, right? In this county, they're doing one thing. In this other county, they're doing something else. And that is causing a burden for one group and not the other group. Try to make that equal protection argument. But you can imagine if it's election day, I mean, you need to have people ready to go out and gather declarations to file these things in court. And it happens. I've done it in Chicago when I worked there. You can potentially make claims under the Voting Rights Act, right? That there are problems with respect not just to regional variation, but with respect to how people of color are experiencing access to the ballot versus white people. And then the other type of claims that I expect on election day may arise are things related to voter intimidation. Actually, one of the other clinics at HLS is the Protect Democracy Clinic, and that group has done some of the best litigation, I think, so far on voter intimidation cases. Again, the federal bench is not super friendly to these sorts of cases. The burden of proof is quite high, but I imagine that there will hopefully be enough sort of recording and documentation of any voter intimidation that is happening that we could not only try to stop it at the time, but actually prosecute it after the election to try to stop it in the future. So they're the things. I'm sorry. And then I wanted to get back to the Minnesota decision and what Nick said. I mean, this morning, one of the election law people I follow on Twitter is Franita Tolson, and she tweeted, "Good morning to everyone except the Eighth Circuit." I do think that this particular opinion is quite well, I guess Rick Hassan says it's outrageous. I agree that it's outrageous, trying to suggest that only the legislature can make decisions when it comes to presidential electors is weird. I mean, the other problem in that case is one of standing. You know, if you're litigating this case, you want to be able to show that you have standing. How do the people who are not yet elected as electors have standing? It seems nuts to me. But anyway, so I had thought that this type of case, that people were being a bit hair on fire worried about it, and yet here we have one of them. I have no doubt, though, that if the legislatures end up changing hands in some places, that there will suddenly be a lot of federal judges that are no longer interested in saying that everything should be up to the legislators, and they'll be about counting every vote. So I don't know. I tend to be cynical at this time of year and see a lot of this as coming out depending on the partisan persuasion of the judges. You should all read Nick's op-ed from today in the Washington Post because I think it's really good. He basically says that when you are litigating these things really quickly at the last minute and the Supreme Court is weighing in on every election case, you get bad law, right? They don't get the facts properly. They haven't spent time. The whole thing of the adversarial process is to spend a lot of time on this stuff. And you can see that these things just get rushed off, and it's a shame because no doubt in 2 years, 4 years, 6 years, we'll be citing to precedents that get set this time, and they will not be well thought through. So we'll have to see. Okay, Cheryl, I don't know if you want to go through and ask questions or how we want to do this.
Yes, we have one question that came up during Professor Stephanopoulos' presentation, and why don't we start with that? We had also gathered some questions in advance of the presentation, and we can also go through those unless folks have other questions. So please feel free to use the Q&A box and ask any questions you have of these panelists. So the first question is, why are courts of appeal, when applying Anderson-Burdick, considering fraud prevention to be so significant a state interest that it outweighs the burden on the vote?
So Nick, I wanted you to answer this because my impression was Crawford, but what do you think?
I think Crawford's a big part of it, in part because courts of appeal follow the lead of the Supreme Court, and the Supreme Court in Crawford, in an Anderson-Burdick challenge, blessed fraud prevention as an interest and upheld Indiana's photo ID requirement for voting, even though there was no actual evidence of any voter impersonation fraud in the history of Indiana. And so it's pretty easy for a federal court that is ideologically inclined to reach this decision anyway to say, well, hey, look, in Crawford, the Supreme Court itself upheld one of the more burdensome regulations on voting, a photo ID requirement for voting. And it upheld it when there was literally zero evidence to corroborate the state's asserted anti-fraud interest. So under the Crawford logic, it's pretty easy to uphold essentially every regulation that in any tangential way furthers an anti-fraud interest. A lot of these regulations are less burdensome than photo ID laws. And well, if there's no evidence whatsoever to show that fraud is a problem or the measure prevents fraud, well, there also wasn't any such evidence in Crawford, and that didn't stop the court from ruling in favor of Indiana. The one thing I will say is that litigant plaintiffs also are aware of Crawford. So what plaintiffs have done in response is often to cast their challenges as applied challenges rather than facial challenges. The effort has been to say, like, okay, Crawford means you can't knock out an election regulation in its entirety when there's some potential anti-fraud benefit of that regulation. But maybe plaintiffs can zoom in on a particular feature of a regulation or as it's applied to certain particular plaintiffs or groups of plaintiffs, and maybe they can carve out some sort of exception or relaxation of a rule for a certain group of people. And that's been a fairly productive tactic for plaintiffs in a lot of these cases.
Yeah, I guess I will add, in our Arkansas case, we managed to look at the fraud interest specifically with respect to ballot initiatives. And the state, maybe to their detriment, highlighted a case from like 1941 where somebody went around pretending they were someone and signing, but that was the only thing they could cite. And so it was relevant for the judge to say, well, look, if that's really all you're getting at. And also in that case, the judge, at least at the district court level, said, the state otherwise lets people sign under penalty of perjury without having a notary sort of approve them in some way. And so it was able to say, well, you're still getting at this fraud prevention interest some other way. I feel like plaintiffs, even in the other cases, have to, you can't say that fraud prevention is an important state interest, but I think you can try to get at, well, how are we protecting that? And so that's why the argument comes up often in photo ID cases these days of, well, you're not actually stopping, like there isn't a lot of photo ID, there isn't a lot of impersonation fraud, and a photo ID requirement wouldn't necessarily stop that. Because people use fake IDs and so on. So I think just trying to make that have more than just it's a really big burden, you can't get over it, is the only way we try to do it.
I would add one more thing too, which is that not all courts of appeals have followed Crawford's lead here. If you look at Supreme Court precedent that's relevant here, it's ambiguous. There's a lot of it. There are pre-Crawford decisions that are more protective of the right to vote. And more demanding of states that want to burden the right to vote. And so courts that are ideologically inclined to dislike photo ID laws can quote that earlier precedent and say, well, look, the earlier cases require states to really corroborate their asserted justifications with real world concrete evidence, and the states can't do that here, so we're going to rule against them. So Crawford doesn't decide the issue completely, because Crawford doesn't supplant all of those pre-Crawford cases to take a harder line against states that are making it harder to vote.
We have another fraud-related question, and I want to ask it in case there's another piece of this that you want to get into. The question is, what's the current state of the law on whether the government has to provide evidence of voter fraud before invoking it as a state interest? The cases, the questioner says, have gone multiple ways.
Yeah, oh, sorry, go ahead, Nick.
I'll just kind of reiterate what I said before, which is that because of the ambiguity of existing precedent, it lets courts choose their own preferred course on this issue. So courts can follow Crawford and say we don't need evidence on the extent of fraud in the jurisdiction, or courts can highlight pre-Crawford cases that require states to substantiate their interest, whatever that interest happens to be, whether it's anti-fraud or something else. Both of those courses, I think, are equally lawful and permissible under current doctrine.
I do think if the state is able to identify actual instances, it makes it a lot harder for the judge to strike down a provision. So just contrasting the case I did in North Dakota with the one in Arkansas. In North Dakota, the state actually did file a whole bunch of stuff, like a statement from the Secretary of State and so on, talking about how he believes that there actually is fraud. And when you're trying to do something very quickly on a PI motion, you then have to get into the fact of whether that exists. And so it meant for the judge at the hearing, he could be like, well, wait a second, this is a real concern. Like, look at all this stuff that the Secretary of State has identified. So I think from their perspective, they should do more than just cite it, but sometimes that's all they need to do.
There's a question about one of the more recent developments. It's in Minnesota, the state's absentee ballots were sent to voters with a form that says their vote will be counted up to 7 days after the election. Is there any recourse for voters who have relied on this prior to the court decision? More broadly, do you expect litigation across the country with similar claims of conflicting rules from the state versus the courts?
Yeah, I mean, I think, yeah. So what they're doing in Pennsylvania is even though they got the relatively good ruling from the Supreme Court, is segregating out ballots. So having the ones that came in on a certain date and then the ones that came in after that date, so that if there is further litigation, which I imagine there will be, it is still possible to identify those ballots and count them. There's also the fact that Nick was saying, right, this is because this is coming out of Article 2, this is talking about strictly election of electors for president. And so you could have different rules for you could have ballots that do count for state races and even like Congress and Senate, but don't count for the presidential race. And then other ballots that do count for all of them. And I know this sounds a little crazy, but it's happened a little bit before in Arizona when there was a ruling that struck down the requirement of proof of citizenship under the NVRA, the National Voter Registration Act. Arizona ended up with a dual system whereby if you sent in the federal voter registration form, you could vote in federal elections, but they wouldn't let you vote in the state elections until you had also provided proof of citizenship. And so there were times when people could vote in one election and not another. So I think it's worrying that what this requires is very careful maintenance of ballots by election administrators. And in my experience, election administrators are trying really hard with limited resources. And there is going to be somebody with a bunch of ballots in their trunk, and we're going to have to work out when they were sent and where they came from and do they count. And if it's a close race, every one of those ballots is going to be, scrutinized. So it is frustrating to not have the rules clear here. I don't know, Nick, if you want to talk about what has been the chatter on the election law blog. I should say, if you want to know what's going on election day, you should follow the election law blog, not just electionlawblog.org, but like sign up for the listserv. It's fascinating. And to the extent that there's Twitter discussion, Rick Hassan, H-A-S-E-N, runs the blog and people tend to tweet at him about it. So that's where I'll be watching for what's going on. But on the blog today, there was some discussion about the weirdness of the Purcell doctrine being that you can't change the rules right before an election. And then now the federal courts themselves went in and changed the rules so that people have determined how they will vote based on one set of rules, and now they've changed.
Yeah, what the Eighth Circuit said about that, I mean, it basically said we acknowledge Purcell, but we think this is too important legally to abide by Purcell's equitable advice not to intervene. I think it's an outrageous decision as well. The court's thinking, I think, was something like, we are convinced under Article 2 that the extension of the absentee ballot receipt deadline is unconstitutional. We could wait to do anything about this until after the election and just invalidate all of the many votes that come in after Election Day. To try to prevent that, the Eighth Circuit may have been thinking, we'll let people know our decision now, notwithstanding the Purcell principle, because this way, at least a lot of Minnesotans will be able to change their voting plans and not vote by mail, use a drop box, vote in person or what have you, and it won't end up casting one of these ballots that don't count because of the radical Article 2 interpretation. So I do think if we're going to have a radical Article 2 interpretation, better to know about it sooner rather than later, and certainly better to know about it before an election rather than after, when the argument can be used to just invalidate large swaths of ballots with nothing at all that voters can do. At the moment in Minnesota, there probably are very few, if any, people that have already sent in their absentee ballots, and those ballots will arrive after Election Day. What it really means is that after the Eighth Circuit's decision, nobody better send in another mail-in ballot in Minnesota.
Yeah, I mean, I will say that USPS guidance was that you would have to send it in by Tuesday, and this decision came out on Thursday. So there may be some Wednesday and Thursday people who are out of luck. I'm sorry, there are more questions. We should keep getting to them.
There's a question concerning what's the best response to the constitutional argument that state legislatures are in charge of fashioning election rules. And this echoes some other questions that we've gotten about just who is responsible for setting the rules.
Yeah, I think the best response is part sort of textual, part normative. The textual response is that under 100 years of Supreme Court precedent on this question, the court has understood legislature in Article 1 and Article 2 to refer not to the institutional body of the legislature, but rather to the state's entire lawmaking process as authorized and designed by the state constitution. And so that's the definition of legislature, the power to make laws through state constitutionally authorized mechanisms. well, then that can include a role for the governor, for courts, for state agencies, and so on. And that is the interpretation the court has embraced as recently as 2015 in a case out of Arizona. That's a sort of textual doctrinal response. The normative response is that who on earth wants state legislatures in charge of regulating anything with exclusive power over any electoral level?
Let me understand that. He knows that many of the legislatures are gerrymandered.
Yeah, state legislatures are, often gerrymandered, distorted, uncompetitive, unaccountable chambers driven by partisan considerations, hardly made up of the best statesmen in the country. You want them to be in charge of presidential and congressional elections. It's not like courts are saints. It's not like governors are saints. But they're not necessarily as bad as state legislatures. And so as far as I know, nobody can offer me any kind of normative defense for entrusting state legislatures with full exclusive authority over the regulation of elections. And unfortunately, doctrinally, we don't have to accept this outcome.
Yeah, another argument I liked, again, this came up on the election law blog listserv, was that state legislatures only exist because of how they are defined in the state constitution. So for example, there isn't what is called a state legislature in Wisconsin. It's that there's a state assembly, there's a state senate, right? And or there's a House of Delegates in Virginia. They have their own names and their own procedures and so on. And so to the extent that the federal constitution talks about the legislature thereof, it's talking about what is set up under the state constitutional system. I find that convincing, but I'm not a judge.
Professor Stephanopoulos, I think this goes back to your op-ed. If election law is often done in a rush with facts not fully understood and poorly reasoned, but we also need election-related cases to be decided quickly, are there systemic changes we could make to how the cases are decided so that there is less risk of, in quotes, bad law?
Yeah, so the Purcell principle, much as I dislike it, is an effort along those lines to give more time for litigation and to avoid having litigation resolved at the last minute when the election is really imminent. I think it's unavoidable when there's a big shock like a pandemic to have a lot of lawsuits relatively close to election day. I think lower federal courts, district courts especially, have impressed me quite a bit with their ability to process evidence, hold trials, and issue really meaty, lengthy, impressive opinions. The bodies that have not impressed me are the courts of appeal, and then especially the Supreme Court. So my column in the Post was not objecting to a judicial review of election regulations close to election day. It was objecting to the Supreme Court specifically sticking its nose into every single electoral dispute all across America. Just note how weird this is. Normally, 1% or less than 1% of cert petitions get granted by the court. So lower courts normally get to decide huge numbers of important issues without the Supreme Court feeling the need to get involved. But now somehow when Alabama has a debate over curbside voting, and when Wisconsin is debating whether to extend a deadline by a few days, and when South Carolina is debating whether to have a notary requirement or not, we need the Supreme Court's attention to this, and we need really poor quality Supreme Court attention to this. That's what baffles me. It's one thing for a court to do it. What I really don't understand is why the Supreme Court has to get involved in what are garden variety electoral disputes.
Director Greenwood, there's a question concerning, for those of us who are planning to be poll watchers on Tuesday, what would you say are best practices for documenting voter intimidation or other burdens on individuals' ability to vote? And this echoes some other questions we've gotten about just what can ordinary voters do if they see things that are amiss at the polls?
Yeah, so the group that I love, the Lawyers Committee for Civil Rights Under Law, runs election protection, it gets called, if you go to 866-OUR-VOTE, O-U-R, vote.org. It also it is also available in multiple languages. I don't remember all of them, but on there you can go through and click through them. I believe they have an app, so you can make submissions, you can call in, you can send emails. They are capturing huge amounts of information. And also, I think it's important to submit that stuff, even if you don't think there's something you can do immediately about it. So for example, if there's a long line, you see people walking away from the line, it's great to get their contact details so you can find out like who got left. But if you can't do that, at least noting that that happened, so that then that is something that can be used for future planning, I think is really important. So thank you for those questions, and please do go to the election protection page.
This is both a comment and a question. Despite the court dredging up Purcell to pretend things shouldn't change close to an election, it's pretty bold for 3 justices this week to sign a statement saying they eagerly await the chance to alter Pennsylvania's rules after ballots are done being cast. Will Roberts be able to retain legitimacy for this court?
You can touch that, Nick, that's yours.
It's debatable what legitimacy this court has in this space already in the eyes of a lot of observers. This is the court that has already decided Shelby County and Citizens United and Rucho and many other cases along similar lines. Roberts, it does appear, even though Roberts is the author of one of the principal opinions taken seriously, the legislature thereof argument, he appears to not want to embrace that argument in the context of an imminent presidential election. So Roberts would have controlled the court on this issue until Justice Barrett got confirmed and replaced Justice Ginsburg. Now it may not matter what Roberts wants or what tactics Roberts can think of. If there are 5 votes to Roberts's right that are in favor of reviving and the legislature thereof argument and revolutionizing this area of law, there's nothing Roberts can do to stop it. I have some hope that Kavanaugh would be similarly inclined to Roberts. It's true that Kavanaugh expressed sympathy for the legislature thereof argument in his Wisconsin opinion earlier this week, but he didn't join Alito and Gorsuch and Thomas in a couple other cases that raise the exact same issue. And Kavanaugh is also the court's biggest exponent of the Purcell principle, which ought to apply to any claim, not just Anderson-Burdick, but also Article 2 legislature thereof claims. So I think there's hope that Kavanaugh might not be on board. And so in that case, there might still be 5 votes against taking this step, even after Barrett joins, even now that Barrett is on the court.
That was hopeful. There you go.
We are at 2:55. I want to make sure that you folks have time to make any closing remarks that you have. And we also have 2 more questions. How would you like to proceed?
Yeah, I have no closing remarks planned. So
yeah,
Ruth, I don't...
Good luck to everyone. Yeah, we can do the questions.
So this question is it the case that that closer we get to election day, the more courts favor not disturbing the status quo? What do you think about the way the 8th Circuit got around this by saying that it applies to the legislative status quo?
I didn't mind your argument, Nick, on that. I mean, you seem to be saying that at least they were telling us in advance that they may do this after the election.
Yeah, they also, so that was an argument for why they should ignore Purcell. Okay. The 8th Circuit also made the argument that under Purcell, they had to correct the lower actors that reversed the legislative status quo. But that's not how Purcell works. Purcell says, what is the legal status quo, no matter who said it. And once you're close enough to an election, that status quo is not supposed to be disrupted. We know from earlier cases that status quo can also include federal district court judgments, even federal district court judgments that the Supreme Court thinks are wrong. We know this from in 2014, there was a situation where a federal district court enjoined Wisconsin's photo ID law. Then several months later, right before the election, the Seventh Circuit stayed the district court's injunction. The Supreme Court then on Purcell grounds lifted the Seventh Circuit's stay. And so we know from that sequence of events that the legal status quo that is protected by Purcell can include amendments to legislative policy that are implemented or ordered by courts. That's exactly what the necessary implication is of that sequence of events in 2014 in Wisconsin. So I think the Eighth Circuit was just wrong and ignored that earlier set of Purcell developments.
The last question is, are you concerned about the notion that GOP state legislatures could seek to appoint their own slate of electors for Trump if Biden wins the popular vote in their states?
I'm not that concerned about that. The way I read Article 2, state legislatures get to choose the mode of appointment of electors. They don't get to pick the electors. So, in all states, they've already exercised their power to direct the mode of appointment by opting to hold popular elections for the electors. At this stage, and certainly after the election, it's too late for the legislatures to take back that choice. Next year, if they want to revisit that choice for the 2024 election, that's their prerogative. But for this election, the die has been cast. The ball is in motion already. And so I don't think they have the power under Article 2 to change their minds and to use a method of appointment like direct legislative appointment that they haven't already committed to. And I'll note too, in the event of disputes over who the valid slate of electors is in a state, there are a lot of complicated issues posed in that scenario. And actually, Cass Sunstein has a recent short paper on some of those issues. But one central point is that the governor of the state has a lot of authority over this under the relevant congressional statute. And in quite a few of the swing states, the governor is a Democrat while the legislature is Republican. And so in a lot of these scenarios there, the governor's judgment will take priority over the state legislature's judgment.
Let's hope it doesn't come to that. Let's just have a big win either way. That's what election lawyers want.
Well, Professor Stephanopoulos and Director Greenwood, thank you so much for taking this time to be with us and to answer our questions. We are very grateful that you took time on such a busy day to be with us.
Pleasure to be here. Thanks for having us.
Yeah, thanks a lot for having us.